Great, well thank you, and thanks to the LTSS for organizing today's event. I think we're heading towards the end of the semester, and to see this kind of turnout is tremendous. And I think in many ways it speaks to the importance of the issue. We've seen a lot of discussion around surveillance really for the last number of years. In some ways the Snowden revelations, I think, kicked a lot of that off. And of course it's been an ongoing theme and an ongoing issue for quite some time. But one of the challenges is very often to have real-world cases that crystallize some of these issues and allow us to engage in, I think, a more meaningful debate about some of the issues and the challenges that arise coming out of it. In this particular case, the notion of when we marry surveillance and surveillance of journalists and freedom of the press presents in many ways an incredibly challenging and important issue. I know at least one person in here, but several of you may know that I run an annual course that brings together the University of Ottawa and the University of Haifa in Israel. It brings Israeli students here, and the Canadian students come together in Ottawa and then go to Israel, and you get a couple $1,000s to pay for your travel. It's a little plug if you're interested in global technology regulation and have the chance to do it. It's a really awesome course. And one of the things that happens with that course is that we visit Supreme Court justices both in Canada and in Israel. What's interesting for me is that we've met with now a number of the Canadian Supreme Court justices, and privacy and surveillance has been a recurring theme when they talk about some of the kinds of issues that they struggle with. But perhaps even more notably is this past year when we met with one of the Israeli Supreme Court justices. He had written on some of the issues around surveillance and metadata, and talked a bit about some of these real challenges of identifying where some of the limits ought to be. And he noted that the lead Israeli case that he had written identified two particular areas where there was specific concern around surveillance and specifically around access to metadata. One was for our community, for lawyers, arguing that client confidentiality and the like could be compromised by access even just to the metadata and the surveillance of that activity. The other was surveillance of journalists, noting that there needed to be very clear limitations on being able to access that information, because in some ways it's not necessarily the content of the message, but who someone was speaking with that might reveal a source and might provide information that otherwise would be critically important and needed real protection. And so these are issues that we're grappling with not just here, but around the world, and this is really at the epicenter of the challenges. We're really fortunate to have three exceptional people to lead us through some of the discussion. We're going to start, and I'll introduce all three and then invite each to come up to speak for about 10 minutes, and then we'll have plenty of opportunity for discussion and questions afterward. We're going to start with Amanda Connolly, who is the national security reporter for iPolitics. iPolitics is really one of the must-reads, I think, when it comes to some of these issues. There are not a lot of news media outlets that focus on these issues as consistently as iPolitics does, and it's Amanda that leads that as she focuses on counterterrorism, foreign affairs, and defense policy. She also is the Vice President of the Canadian Association of Journalists for the National Capital Region, and she's here representing the CAJ. So particularly well placed given both the focus that you have day to day as well as your focus working representing the CAJ. Second, we've got also two people from within the law school, who both I think need no introduction to just about everybody in the room. First, my colleague Teresa Scazza, who holds the Canada Research Chair in Information Law. She's the founder and former editor of the Canadian Journal of Law and Technology. She's a member of the External Advisory Committee of the Office of the Privacy Commissioner of Canada, and as well as on the Canadian Government Advisory Committee on Open Government. She's been incredibly outspoken through her blog and in the media and through her research on issues surrounding privacy, open data, as well as surveillance. And then we also have someone who also needs no introduction and doesn't seem to sleep, and that is Tamir Israel, who is staff counsel with CIPIC. He focuses on just about everything at CIPIC, it seems, particularly around digital rights issues, with a focus on online privacy and anonymity, net neutrality, electronic surveillance, and the like. He's also a member of the advisory board of Privacy International and lectures here in the faculty. In addition to his work as staff lawyer, lectures here regularly with the faculty on internet regulation matters. So we've got a terrific panel. And with that, we'll start by turning over to him.
Thank you so so much. Thank you to Michael for those kind words, and for you guys for bringing me out here today. I'm very excited to be here and to talk with you. If you can't hear me, let me know, and I'll try and speak louder. So just give me a heads up if you can't hear me in the back there. Yeah, so what I'm here to do really, I don't have a legal background. I'm here to kind of give you more of a journalist perspective on these issues. Of course, as Michael mentioned, I cover these. This is my beat. Security, counterterrorism, surveillance. These are the things that I work on every single day here. And so I thought it was kind of be interesting to give that perspective to you guys. And I was thinking last night, I was kind of casting my mind back for what I was going to talk about today. And it got me, thinking about back to when I was in journalism school. So I went to Carleton. I started in 2008 for my bachelor's program, and I graduated in 2012. And one of the things that we had to get when we started at Carleton was this book right here. Now, if you can't see the title, it's called The Journalist's Legal Guide. This was essentially our handbook to all of the rules, the legal implications, everything to do with, search and seizure, interception, search warrants, kind of whatever you can think of in that regard, and so many other things as well. And I started going through it, and just for context for you guys here, in 2010, when I was in second year, we had just gotten Twitter. None of us had Blackberries. I can still distinctly remember the first time a source got mad at me for not responding fast enough because I had to actually go to a computer and check up on something after her phone call. So, to say that things have changed a lot in the past couple of years here is really an understatement. Really when you actually kind of get into how much they've changed, the game is completely different these days. And I think that, it looks familiar and it feels familiar to what we were taught in school and what we thought it would be. But the rules are not what you thought that they would be, or what you were taught they would actually be. And in a lot of cases, there really isn't a rule book. Again, this book here was our rule book when I started out, and it's pretty much obsolete right now in terms of the issues of surveillance that we're talking about right now. I was going through it, and there's not a single mention here of metadata, the section on police surveillance and search warrants. They only deal with physical documents, so it's cases of RCMP actually going into newsrooms and saying, you have an envelope, you have a bank record, we want that, and give it to us. There's not, I literally combed through the entire thing being, this can't be right. There must have been some indication or a mention of this, given how prevalent it is right now, and there's not. And I think that really just goes to show you, again, how much the world that we know and the world that I operate in and the world that you guys are going to be operating in has really changed completely over the past couple of years. Now, to put it frankly, what we're seeing right now, what we've seen so far in Quebec, what we've seen with regards to police surveillance of journalists, with regards to monitoring of their communications, what we're seeing right now scares me. It scares me for my colleagues, of course, who are doing nothing wrong, but upholding their duty to as we say in the industry, afflict the comfortable and comfort the afflicted. It makes me afraid for my sources, because a number of them have already told me over the past year they've received threats from RCMP for information that they've given me in terms of RCMP coming into their offices, searching for information, searching for records of how they've communicated with me and with other journalists as well on a number of issues. It makes me afraid for the next generation of journalists, people, whether it's lawyers or people who are going to be coming into my field right now, who are kind of at a disadvantage here. You look at the cases that we've been talking about recently with Patrick Lagacé, with Vice News, and I think that the difficulty with that for the new generation coming up is that the work right now is so precarious. A lot of them aren't going to have the backing of big media organizations or people who actually have the capabilities to go through a lawsuit to actually say to the RCMP, no, we're going to spend years in court with you pushing back on this, we're not going to hand it over. The work right now is increasingly freelance. I'm lucky to be in a situation where I do work full-time for a new media company that is able to navigate as well these legal threats and that kind of thing. But for people who are just coming into it, if you're starting out and you have a story perhaps that involves information that you're not supposed to have, confidential sources, documents, things like that, and you find out that you're being surveilled or you're being monitored, you don't necessarily have the resources on your own to challenge that. And given that so much of the work nowadays does revolve around that thing, I think that puts them at a real disadvantage, and that's concerning. And above all, it makes me afraid for the public, because what happens when you don't have journalists who are actually free to do their work, and sources that are comfortable talking to them, is that you lose that interplay between the public interest and the fourth estate. And what we're doing here, again, we work in the public interest. And so, as we saw in the recent cases in Quebec, the journalists who were being monitored, they weren't, dealing with, necessarily breaking the law. They were dealing with whistleblowers in a lot of cases, people who saw wrongdoing, who saw issues that were not being addressed in the system, or they saw that the system wasn't equipped to handle the concerns that they had, and they went to the media. And in a lot of those cases, the media reporting on those issues prompted changes that I would argue better serve the public and ensure that there is more accountability for what is being done both in the police force and the construction industry, and things like that. And so, I'm not going to stand up here and say that this issue in particular is clear cut and there's one right or wrong answer. It's hugely complex, and of course you guys know that, of course, being in law school and dealing with the kind of ins and outs of what the current laws right now allow for, and what is going to be happening over the next couple of years as things go through the courts and get challenged and evolved, and all that kind of stuff. So, as well, we're starting to see kind of more fulsome discussions as well about privacy, about surveillance, about press freedom, and of course as well about security, and how all of those different things come into play together. And they really aren't, you can't break them down anymore into separate silos or separate issues. They're so interconnected and so interrelated that when you talk about one, you're kind of by extension talking about the other ones as well. We haven't really, we've seen in countries like the US as well, I think that there's been perhaps a deeper level of debate around a lot of these things with, Apple, the San Bernardino shootings, with more issues around kind of what the thresholds are for surveillance, for police seeking information from journalists. And here in Canada, up until now, we really haven't had a full conversation about that. We've been kind of teetering on the edge of it, as I guess I would kind of characterize it. And right now, I think we're kind of right on the threshold of actually jumping in and having a really kind of fulsome and fruitful discussion about that. We hear it from Minister Goodale a lot as well, that he wants to see more of this. It comes up whenever you talk to him. He always makes sure to kind of put that into the conversation there. And people are starting to, I think, pay more attention to it. We're hearing it with regards to things like encryption, which a couple of years ago, people, apart from hackers or people who were really, really keen in that kind of parts of the internet and things like that, really didn't deal with encryption. And nowadays, when you buy a new Mac, one of the first things it asks you is, do you want to encrypt your hard drive? So it's come into a level where this is kind of mass availability, and people are having to learn about it in a way that they really didn't have to before. And I think people hopefully are going to take the time to educate themselves more, and they're going to look to people like the media, like people who are working in law, who are working in academia, to really make sure that we are leading the discussion about that and making sure that we are contributing in a way that makes that a productive conversation for people. So, of course, we can talk so much about the type of information, and Michael mentioned as well, when you're collecting things like metadata, you're not just collecting, what the information that you go in there looking for. You could be looking for who a person is talking to and end up with, 15 of the people that they call in the space of an hour. You could watch their phone for an hour and see, that they are talking to this place and that place, and make all kinds of inferences that may not necessarily relate to what you're actually looking for in terms of tracking down a source. And so that's a huge concern, I think. And I think when it comes to particularly the discussion about surveillance of journalists, as I mentioned before, and how that relates to all of the other issues that we see with security, with so many other issues here, there really kind of often is a connotation that can be, I guess, in a sense, negative in some ways, and that when you're dealing with reporters who are dealing with information that maybe wasn't public, that it's a threat that has to be contained. And I think that looking at the conversation through that lens can be really dangerous as well, because when we're if we're working with whistleblowers, or we're working with information that isn't necessarily public, the media is never out to cause harm. We're always doing we're working kind of because we also have a vision of fulfilling a responsibility to the public. And we may have different opinions from law enforcement a lot on how that actually operates and kind of how we achieve those same goals. But we do work with a lot of the same goals to make sure that society is safer and more constructive and positive in that. And so I remember back in journalism school, we had an ethics workshop, and part of it came from what we were talking about in the legal guide here And a lot of it was looking as well at things that were happening at the time with regards to terrorism and things like that. And it kind of touches on the issue of how we talk about security and surveillance. My prof said to us, if you are in a position where a source comes to you and you receive information of an imminent threat, so something that is going to be causing, you are the only person who has this information and there are lives on the line and something will happen if you do not reveal what you know to law enforcement. What do you do? And I think we came back the next day and he took our answers and he went through them and he talked to us and he said, not a single person in the class who was given this scenario here would have said that they would have not revealed either their source or the information that they had if it meant protecting the public safety in the event of an imminent attack. And I think that really speaks to the shared interests and the shared goals that we do have here. Again, we do want to see the public safe. We're not doing these kind of things because we want to cause harm. We're doing them because they are legitimately in the public interest to reveal some of this information. And in cases where there actually is an imminent danger, I think you'd be very, very hard pressed to find a journalist who would not say that there are cases where you can bend some of the rules with regards to confidentiality and things like that in the broader interest. And so I think understanding that there are common areas of interest and that there are areas where we can work together with law enforcement and with people who also want to see those goals come about really is going to be vital as this conversation develops and we kind of get more into deeper areas of it. Journalists, we do what we do because we believe in a strong democracy and we believe in the fundamental right of the public to cast an informed ballot when they go to the election, when they go into a voting center, when we work with whistleblowers or with confidential sources or we deal with information that we are not willing to give to police or to law enforcement, it's because, again, there's a valid public interest in sharing information that reveals a problem Canadians wouldn't otherwise know about. And so when a law is broken, if we do something wrong or we do violate something, the courts are a valid recourse mechanism to go through that. If there is not enough evidence or enough, justification to take that to court, to lay a charge and things like that, that's where you get into more of the trickier issues here. And I think that, as I said before, the game has really changed and the rules that we thought we were going to be working under are no longer the case. And so for us, given the prevalence of lone wolf terrorism, of, whistleblowing, with the Edward Snowden cases that are really enhanced by the digital world, and the mass collection and analysis of data, we come to the problem from different sides of the same coin. And I think realizing that and looking for areas where we can work together to increase the public's awareness and their ability to contribute to the conversation is really the kind of key thing going forward that we need to focus on rather than the differences. That said, there are a lot of differences and they're very serious, but I think that there is a way to hopefully find a solution that is balancing the needs that we have here with the needs for public safety. Thanks.
Thank you. And I'd like to just begin by thanking the LTSS for their efforts in organizing this event. It's great to see so many students come out and be interested and engaged in these kinds of issues that are really, as Amanda has said, very fundamentally important to us. In terms of the Lagacé case, I think is a really tremendously interesting, I say case that hasn't gone to court yet, but situation, context, is a very interesting one and raises a lot of, I think, important issues. I'm going to try and flag some of those for you. On one level, it can be framed as a journalist confidential source issue, right? So it's an issue about what protection do journalists have for their confidential sources when it comes to, police investigations. But it also raises broader privacy issues. And it does so at the same time because it's not just, it's different in some ways from the kind of situation, and Amanda mentioned the conventional case law, and there are quite a lot of Supreme Court of Canada cases that deal with journalists and protection of journalist sources. It's not the kind of situation that blows up around the police wanting a search warrant to get in and search the premises of a news organization because they're looking for something specific. This is a context in which there is surreptitious ongoing tracking and monitoring of the community, of not only the movements of journalists, but also of their communications with anyone. Okay, so there's also a privacy dimension to it, a significant privacy dimension, which is almost could almost be a persecution type context for the particular journalist. So it's not just that it's a journalist source issue, but you've also got journalists who themselves are being followed, tracked, and having all of their interactions by phone or by text message recorded and monitored. Not necessarily the actual content, but the metadata. And so this goes beyond just the confidential sources and also impacts on the journalists themselves. So I think that's the first point I want to make. The second is we've heard about the particular value that courts place on the journalistic role. And the courts have said in this case law that we have that talks about the protection of journalists' confidential sources, that journalists have an important role to play in a free and democratic society and preserving the values of a free and democratic society. And the courts have said that interference with that role is a public harm. Okay, so that's the starting point, that there is actually a public value in protecting journalists' confidential sources. It's not just about letting journalists live the kind of life they want to live, but it's about all of us. It's about the society that we live in. But they've also mandated that we have to strike a balance between the public interest in a free press and the public interest in law enforcement, the detection and investigation of crimes. Okay? So that we have these two competing considerations that have to be balanced. And that's great. But the thing that I want to flag there is, and this is a problem that comes up all the time, and some of you may have heard Michael talking about this in the media this week with respect to the police asking now for greater powers to break encryption and to do technological surveillance. That on the one hand, we all, at a very instinctive gut level, we understand crime control and prevention, right? We've all been victims of crime, or we know people who've been victims of crime, or we're concerned about being victims of crime. We sometimes adjust our behaviors. We get alarm systems in our homes. We don't walk in certain areas of the city at certain times of the day, because we understand, we get it. We understand threats to crime, right? At a very instinctive level. The free and democratic society thing, I think we tend to take for granted. Most of us, not all of us, because there are Canadians who've come to Canada from countries that are not free and democratic, but most of us have always lived in a free and democratic society, and we kind of take it for granted, and we kind of assume it's always going to be there. So I think it's harder to imagine what we're doing to our free and democratic society through these incursions and encroachments on privacy. And so when we start talking about the balance, in that balance that's being struck, we have on the one hand something we get at a very fundamental level, and on the other hand something that we kind of think, well, if I haven't done anything wrong, I have nothing to worry about it, right? We just kind of take it for granted. And so I think that's something we have to be very careful about, because there's a real risk that we will underestimate the harm that is being done to our free and democratic society by simply taking for granted that it's always going to be there and that it's robust enough to withstand any of this. So that's another thing I want to flag. And then, and this is almost like thinking in footnotes. And I'm sorry, if you do this job for too long, then that's what you end up doing. It's kind of, it's probably kind of form of brain damage. But anyway, so here's another footnote that I want to place before I get into the media. And that's on the word journalist, because we're talking about journalism. And I just want to note, Amanda again also mentioned sort of the changing nature of the profession of journalism. And the courts, and we have all of this case law that talks about journalists and journalism and that balance. But we also have a really dynamic and rapidly changing environment in terms of how information is communicated to the public and who is communicating that information. And so while the court jurisprudence is very clear about journalists, although they don't define the concept, I think we have to be less clear about who the journalists are in our society and which of them are entitled to the kinds of protections that the courts talk about. So that's another footnote. Okay, now I'm going to try and get on without many more footnotes. Okay, so many of the legal battles, as Amanda's already mentioned, that have gone to the Supreme Court of Canada around the protection of journalists' confidential sources have been ones which have dealt with or have involved police looking for specific things that are in the hands of journalists. And because of this, and I can give you a few examples, the famous National Post case, which came up around the sponsorship scandal in Quebec, information had been handed to a reporter in a sealed envelope. The police really wanted to know who the leak was and thought there might be some DNA, useful DNA on the envelope. They wanted the envelope. And the envelope was on the premises of the National Post. And so there was an issue about whether the police could have access to that envelope. The issue that arose this fall and hasn't gone to court yet, involving a reporter from the Journal de Montréal, involved a leak, confidential communication, a video that was, according to the reporter, sent to the reporter. The police believe that the video might have been obtained by hacking a website. So they want the computer in order to be able to tell whether there had been a hack, whether the information had been obtained through hacking. So again, physical object in the possession of the reporter on premises. And there are lots of other examples. So that's the typical paradigm. And so there you have a building, you have people in the building, you have the police that want to come and search the building, and you have a conflict that's very obvious and evident and visible, and then you have case law. Because the media institution, and I think it's important to note, as Amanda did, these have all been large media institutions with the resources to fight. But the media institution fights back and says, you shouldn't have this search warrant, and let's argue about whether it's appropriate in these circumstances. And so you get case law, and you get principles, and you get the courts talking about this stuff. The kind of situation that you have with the Lagacé case is very, very different, and as a result, very, very troublesome, because all of the surveillance, the tracking of his cell phone, the production orders for all of his calls and text messages, all of that happens without any need to physically interfere with Monsieur Lagacé or with his employer's premises. It just all happens in the background. And he might never know. He might never have known that that was taking place. There are journalists after he came forward, after he found out, there were journalists who then discovered that they too had been the subject of this kind of surveillance, often for significant periods of time. How many other journalists in Canada are yet to become aware of the fact that this has been taking place? So this is a very different context in which, although the courts have talked about the need for this kind of balancing, the balancing works best in the old paradigm where the two parties have to, come into conflict and ask a court to resolve that conflict, as opposed to a paradigm where nobody may ever know that it's taking place. And it all depends on the relationship between the police and the justice of the peace who issues the production order or the search warrant, as the case may be. The other thing that's different is, of course, with the tracking, there are lots of stuff that's different with the technology, but with the tracking, the order for tracking of a device that somebody carries, so we all have cell phones in our pockets or bags or whatever, they all emit signals. You can actually go to a court and get a warrant to follow that signal. You have to, it's on a reasonable grounds to believe basis, which is at the higher threshold for getting a warrant if they're going to be tracking your cell phone signal. But still, nobody has to kind of find a way to place a bug or do anything like that. You were already carrying it. It just has to be switched on. With the production orders, these are orders to the telecos to provide records of all of your cellular communications. Those have already been collected, they already exist, and the warrant threshold is reasonable suspicion. Right? So you don't even have to get to the same level, you just have to have reasonable suspicion, and all of that data is just sitting there. Right? And so that's a concern as well, or that certainly should be a concern, because you can just go back into that data, get it with relative ease on a reasonable suspicion basis, and it's already been collected. In these cases, I think it's also important to keep in mind that Monsieur Lagacé was never himself a suspect. The journalists in the other instances were never themselves suspects. They are third parties. who have been put under a significant amount of surveillance in order to get at perhaps their confidential sources, and who knows what else, okay? And so that is another factor, I think, that has to be put into the mix when you're talking about this kind and this level of surveillance, that you're also dealing with people who are third parties. The sheer scope of this kind of surveillance in the journalistic context is also significant. It expands the workplace beyond the building, the desk, the computer, to all movements, all phone calls, all text messages. It essentially expands the workplace into the personal life of the journalist. Right? There's all of those corners are exposed, and that's significant. It expands it from the span of a few hours to weeks, months, potentially unlimited periods of time. So it's extremely invasive temporally as well. And of course, it has this potential for a chilling effect right across the board, because it's not the envelope that was provided by one particular source that it's at risk, but it's every single person that that journalist has had communications with. Even if the investigation is about one particular thing, if the production order covers all of the phone calls, all of the text messages, all of the communications, then it exposes everybody and has this potential for an enormous chilling effect on the practice of journalism generally. The other thing I want to note with respect to this particular instance is there's a bit of a stink coming off this one, okay? I don't know if you've been following it in the media. Did the mayor get a speeding ticket that got forgiven that he didn't pay for? Is he ticked off because someone called Patrick Lagacé to tell him that the mayor is getting off on speeding tickets and not having to pay for them? Was there something else that the mayor might have done that got him annoyed, that caused him to talk to the chief of police, that went down the... I don't know. But it stinks. There is a whiff of something not quite right. We're not talking about the sponsorship scandal and billions of dollars in taxpayers' money. We're not talking about fraud and criminal organizations involved in the construction industry in Montreal. We might actually be talking about a reporter who has ticked someone off in a position of power because they're asking questions about the exercise of that power. The case involving the computer and the Journal de Montréal reporter, in that case, this was a judicial conduct that was being investigated. And the complaint to the police came from the Quebec Judicial Council. Again, kind of, these are the people in power. These are, authorities responsible, presumably, for maintaining order, maintaining the Constitution, doing all these good things in society. And when you start to see that kind of whiff coming off, I think that raises very significant questions and concerns as well. So I think I'm going to just close there with that as well, because I think this is, because I just want to underline the fact that although we're talking about this balance between journalism and the power to fight crime and the public values there, I think that there are also other issues here about power and trust and democracy in society in these particular cases, and that just the tremendous capacity for abuse that we have to be thinking about as well. So I'll stop there and sit down. Thank you.
So yeah, I just wanted to also just start by thanking the LTSS for hosting this panel. It's been a great discussion so far, and I've enjoyed it. And as my panelists have mentioned, the press does play a very critical role in our democratic society. It's one that we do probably take a little bit for granted sometimes because we expect it to be there and expect it to play the role that it plays. But there has been, again, as is coming out from this example, and as you've heard from the examples coming out from my colleagues, there's been an increasingly sustained, effort to leverage journalists in a variety of contexts as means of carrying out investigations, which is recent, and can actually change the underlying balance that we rely on almost intuitively to be there for the functioning democracy that we live in. The drivers of this shift are numerous. One of them is technical, right? So it's a lot easier to basically survey journalists surreptitiously, as Teresa was saying. But I'll give a few other examples where journalists have been used, or have at least their information has been implicated in ways that could be used in ways that are potentially problematic and could lead to a chill of not only their ability to carry out their job, but also of their credibility with sources. So so there's a lot of generalized. So we heard a couple of weeks ago, following I think it came out a week after the Lagacé example. We heard that CSIS has been collecting mass amounts of metadata just from open source online data sources and amassing them without any legal justification for doing so. They got criticized by CERC, the committee that oversees CSIS, CSIS being our intelligence agency, for those of you who are not aware. And they then later got criticized by the federal court for failing to meet their legal standards and limiting their collection to what's necessary. So what we have here is a database built of online, basically online activity, which includes mostly metadata, like who's interacting with who, and isn't targeting sources, but is a general capability that, but that can then be used, though, at any given point in time to basically reverse engineer a source type relationship or a journalist's activities. So it could be something as innocuous as, we saw this actually following Snowden, where I don't know if you people know what, so PGP keys are little encryption tools that let you send emails to people and encrypt them. But what you do sometimes when you exchange PGP keys is you sign them on a public server. And what happened was, retroactively, people were able to see that when Edward Snowden started interacting with Glenn Greenwald and some of the other reporters that he spoke to get his story out, one of the first things they did was sign each other's PGP keys. And this was, if somebody had been looking for that at the NSA, for example, they would have been able to spot that ahead of time and potentially actually preclude the whistleblower from getting out to the source, I guess in this instance, from getting out to the reporters and getting his full story out in time. So that's one example where, like, if these general capacities that map these types of interactions that are available can be leveraged to actually preclude sources from getting to reporters in a critical way. And I think that some people will disagree as to whether the Snowden disclosures were on the national security side, there's some the agencies would have said that that was not the appropriate avenue for that information to get out. But I think from a public interest perspective, it sparked an immense debate that's been resonating for around the world, and most people have said that those disclosures have provided immense public value. So it would have been unfortunate had that type of open source surveillance capacity precluded this important type of information from coming out, and it's these types of databases that facilitate that. So that's one. There's other tools that we've been examining called. There's also the ability now. So malware and spyware is something you're all familiar with from your day-to-day lives. It's something that you try to avoid on your own computers. But we've from some of the Snowden revelations that have come out, we've seen that. The National Security Agency and other comparable agencies around the world have been willing to basically target some journalists and infect their devices and with spyware and malware, so that when these journalists go to places where these agencies aren't able to go to conduct investigations and try to get sources in conflicted areas to talk to them about things that are important for the public to know. The NSA can basically piggyback on that and use them as unknowing accomplices in their investigative efforts and their intelligence gathering efforts. Now, this doesn't have the problem here is that when people find out about these types of activities, as they occasionally do when we get a leak and a whistleblower and the information comes out, it really undermines the ability of journalists to go into these areas. They're now targets because even if they are well-meaning in and of themselves, the sources that they're trying to get to interact with them won't even know if they've been unwittingly co-opted as tools of the government that these people see as an enemy. And I think we still recognize that even though there are very difficult safety challenges and national security challenges in our world today, it still is important to find ways for reporters to get into these places and to talk to these people and to do the job that they've done historically. So that's the second one, technical capacity. A third one that we've looked into quite a bit is called a cell site simulator. It's basically a little device that pretends to be a cell tower and lets law enforcement surreptitiously track individuals without going to Apple or a third-party provider to actually serve them the production order to get the GPS type data that was obtained in the Lagacé case. So these types of tools allow law enforcement to increasingly obtain information without any third-party involvement and without any ability for the request to get challenged by a third party. They do sometimes need to go to court and convince a judge on an ex parte basis to grant them authorization to use some of these tools, not all, not in all instances. CSIS did not feel that they needed to get authorization in their metadata collection efforts. And the NSA also gets very generalized authorizations for these types of activities, not specific ones. So no judge says, yes, it's okay for you to install spyware on this journalist's device for this purpose. They just have a general authorization to do these things. But in the case of law enforcement, they do sometimes need to go to a judge and convince them on an ex parte basis that that there is a need to follow this particular journalist. But because it's an ex parte application, the judge doesn't hear the other side. It only hears the police side. They will not necessarily include the phone call from the mayor that may have that is upset about somebody talking about his unpaid parking tickets and may have spurred the entire investigation. Whether that is actually the impetus for the search or not, that won't be included. They won't include they won't necessarily include the full context. For example, there were two surveillance activities that implicated Lagacé. One of them followed on the unpaid parking ticket scenario, and there was and the other one also, I think, and there the question was, the putative question was, did a police officer give Lagacé information related to this unpaid parking ticket, which they shouldn't have done. The other instance had to do with a police corruption investigation. And again, when you have police going to a reporter to try to find out who a police officer that's reporting on corruption, that's whistleblowing on corruption, without anybody knowing about it, that's a potentially hazardous situation. Lagacé himself said that the information that they presented to the judge as justifying the search was actually not information that he had revealed in his story. It was actually another press outlet that had revealed that. But in an ex parte situation, all the judge has is what's presented to him. So you don't have anybody challenging this evidence and presenting another side, presenting the potential counter implications. So a lot of these get approved often when they maybe shouldn't. And on ex post review, judges apply a different standard for assessing whether the order should have been issued. So a lot of these orders get retroactively approved against journalists in particular, even though they may not have been approved at the outset had a judge gotten the full story. So that's an issue with how these general powers are structured and how they lead the checks and balances that we typically rely on, even where it's not a surreptitious search situation, are not always able to alleviate the harms that can come from these scenarios. Making matters worse is a range of powers that have been introduced and are in the process of being introduced, which treat, as we've heard, about metadata in particular, as less sensitive and less in need of protection by law. This is a historical quirk where, when it had to do with basically like almost the telegram era, like the fact that the signal on the telegram was fairly exposed when it was sent from one place to another, and then later on, old wireline phones, the signals that were being sent from one phone to another were fairly exposed, and they weren't treated as private because even though they revealed who was talking to who, they weren't treated as private as the content of phone calls. In the era of digital communications, where you have mass interactions revealed by almost everything that you do, every text that you send, every email that you send, every Facebook or person that you add to your profile, every LinkedIn person on your LinkedIn profile, etc. You can paint very detailed pictures about people just from their metadata. but the law has still hung on to this concept that metadata is less protective, even though it can, in many instances, reveal, reporters interacting with sources and these types of activities which are very, very sensitive from a democratic perspective. So we have a number of powers. Teresa touched on one that was introduced in C13. A number of them were introduced in C13 that let police gather metadata, like who's interacting with who and where they're and GPS information where they are at any given time at lower thresholds that are not difficult to meet and to justify. We have our intelligence agency, the Communications Security Establishment, Foreign Intelligence Agency, which has a very kind of carte blanche regime that lets it gather metadata en masse. It has massive databases with metadata that it just basically intercepts off the internet and can be used again to retroactively or proactively see which reporter is dealing with who. We have other foreign intelligence agencies like CSE who've been willing to use that type of data for that objective. And then we have a few powers coming down the line that have been introduced that would make it even harder for reporters to securely do their job without having to worry about their sources being outed ahead of time or retroactively. We have the government introducing a warrantless online identification power, which could be used again to leverage anonymous interactions, like that would just be an IP address interacting with another, and turn that without any judge involvement or any need to show reasonable suspicion or even into a real-world identity. And if it's a source interacting with a reporter, then you have your whistleblower. In that scenario, that's been a proposal that was recently introduced by the government that might become a law soon. We have the government talking about restrictions on encryption, which is a tool used by reporters still to try to protect, shield some of their communications and their interactions for the very reason that they don't want their sources outed or even their stories precluded before they get a chance to tell them. And we have a proposal for a data retention law, which would obligate companies such as Google and other online communication tools to keep track of all interactions that happen on their site, or WhatsApp I think is a good example. So they don't currently they don't keep track of who's interacting with who on their instant messaging platform. There's other instant messaging platforms that are often used by reporters, particularly reporters interacting with sources in other regions and other countries that are difficult to reach, that don't keep track of who interacts with who all the time. The proposed law would obligate them to do so and then make that data available to law enforcement upon request. Again, undermining the ability of reporters to interact with important sources of information and to get at important information that we as the general public have historically relied on being able to get through the avenue of reporting. Just to show that this isn't, this has already had some impact. So following on the Snowden revelation, this is my last point because I'm now at 14 minutes. Following on the Snowden revelation, a comprehensive study was done by Human Rights Watch and the ACLU, where they interviewed, I think, like 100 reporters from major and minor news outlets around the world. They all reported increasingly that they were running into government sources were increasingly worried about talking to them, even about things that were not that did not involve classified information that were legitimately within their purview to talk about, but they were worried about talking to them because they were worried that they would get found out. They were worried. The reporters themselves experienced a chill. Reported experiencing a chill when assessing what to do about interacting with people in say war-torn regions or regions where there is questionable national security implications of talking to individuals. So even just 1 year after the Snowden revelation, just from hearing the amount of surveillance that's been leveraged at reporters and at the general population, this chill was already taking place. And we've only gone further down that road since then with more examples of reporters being targeted and generalized powers being introduced. So I think, I guess that's the point I wanted to leave you with. It's not a hypothetical kind of concern. It is one that's actually impacting on the ability of journalists to do their work. And it's important work, and hopefully some more safeguards will be put in place against this.
Thanks, Tamir. And thank you to Amanda and Teresa as well. I think that's a terrific start. It really highlights the real-world challenges that journalists face, some of the legal considerations, as well as some of the background and things that don't, some of the stink, as Teresa described, that underlie some of these cases as well. So we have a fair amount of time, which is great, and I'm happy to open the room up for questions.
This is Permanent for Kinnear. If I understood I think I understood this properly. When you're talking about metadata, so you're saying metadata is less protected now. Do you think that as we evolve to the next big thing, or small thing as it seems to be, that metadata will become more protected, like phone calls are now more protected than they were 20 years ago, 30 years ago?
I mean, that we've been advocating for that internationally and domestically for quite a while. There's some encouraging developments along that front. Our Supreme Court issued the Spencer decision in 2014, which identified a type of metadata as being very sensitive, and our Supreme Court in particular has talked about online interactions as being more sensitive, but it's a very, or here as well as around the world, we still have much stronger protections for content than metadata, and it's a very difficult concept to dislodge. So I hope so. I mean, we see people increasingly recognizing that, but at the same time, we also see the discussion kind of, the discourse kind of goes back and forth. So we also see, we still see claims from law enforcement repeatedly made that this information is less sensitive and we shouldn't worry about its disclosure as much. All it is people interacting with people. So I mean, it's hard to say, but I hope so.
It seems like one of the themes that kind of came out in the talk was this idea of the objectives of the journalists that we're talking about are always for the greater good, for lack of a better word, or for public safety, or for the protection of public interest. And it seems like over recent years we've definitely seen a shift in the definition of journalists, I think as you were mentioning, and how now we see a lot more citizen journalists, and maybe people who are writing for unofficial blogs or unofficial websites. And I'm just wondering, I guess, to what degree, well, this come the wrong way, but we can distinguish like the good journalists from maybe not so good journalists, or journalists who aren't doing it for the right objective, for lack of a better word, and where that comes into play.
Yeah, I mean, I think that's a hugely important question. It's one that we're still dealing with ourselves, particularly in the context of things like breaking news situations when you have so much information coming in, online on Twitter and things like that, for example, and people, there's no real clear standard of who to trust and who to retweet and who to take with, an extra grain of salt versus a salt lick when you're actually seeing what they're posting. Online there are things like verification badges that help with that kind of thing, where you can say, this is deemed in the public interest. They have a history of posting reliable and credible things. But when it comes to these situations that we're talking about here today, I think it's a lot harder because, as you mentioned, you do have people, you have bloggers, you have, I guess, citizen journalists is, I don't know if we still, I guess we still use that term. And it really has become difficult, especially because so much even, work for larger outlets too these days is precarious, is part-time, is contract, is not necessarily, you work, 40 hours a week as a reporter, you file X number of stories, and that's what proves you are a reporter. So it's, it's a tricky balance, I think, and I think that when you're looking at where that comes into play, again, it's, I think you're generally hard pressed to find reporters who are maliciously putting out information like that. But again, and I think that's where the courts really come into play, is that you have to be able to say, if you have a reason, if the police have a reason for wanting information, there has to be, as my panelists mentioned, a third party and a way for both sides to say, this is what I want, this is why you can't have it, and a person in the middle who can actually balance out both those arguments, as opposed to the police going to a justice of the peace and kind of getting whatever they want. So I think that, again, being able to kind of have not a mediated discussion there, but more of a public and open discussion about that when they come up in these kinds of situations is a big part of that, but there's still no clear answer of who is and who isn't. There never really has been.
Although I have to wonder, just to follow up, I mean, if we see what's happened, just obviously in the United States, whether it's Breitbart or InfoWars, I mean, those people would say they're journalists, I assume.
Yeah.
And there was I think BuzzFeed had a chart out yesterday that suggested that false news was being more shared than real news in the lead up to the presidential election. So it makes it really, I mean, it isn't the notion that journalists don't have a malicious intent. I think I don't know, is that really still a fair conclusion to make? That's not to suggest that or entities that I think many of us would see as legit, but there's obviously a community of people that see some of these other sources as legit, and many others would say that they're quite malicious, and obviously we've got President-elect who keeps suggesting that the New York Times and the Washington Post and CNN are being malicious.
Yeah, very, very fair point.
Yeah, I was going to say, to complicate matters, it hasn't been completely unknown for some countries to actually place reporters as intelligence agents also. So just to throw another wrinkle, but I think at the end of the day, the courts are the ones who should be making that determination, not, and we're lucky to have good courts in Canada, but not political. It can't be left to the political or the executive branch because they're operating under very distinct incentives. Like when they're doing an investigation, they're operating under specific incentives. When they get a call from the mayor about a parking ticket, they're operating under specific incentives. It has to go to a third party, an objective third party, and both to determine whether in every case whether it is kind of a false or more malicious type of scenario, or if it is one that's more legitimate.
Will there be a need to regulate IT professional a little bit more to ensure public interests are kept in a digital world?
By IT professionals, you mean like the people who respond to the requests?
Well, the person that build and that build and engineers networks that we use daily, that build the platform we're using.
And in terms of regulate, do you mean regulate the platforms or regulate the people?
Well, for example, professions such as engineers are regulated to ensure public trust is the most important aspect. But when we think about the IT profession itself, it might not be regulated as much as some other more traditional aspect, such as engineers.
Related to that point, I think we've seen an interesting development first in the United States and then quite a bit later in Canada with respect to voluntary transparency reporting on the part of some corporations. So telcos to begin with, but other corporations are also participating in the voluntary transparency reporting. And that's because under both the Criminal Code and under in Canada, the Personal Information Protection and Electronic Documents Act, third parties that have personal information can have it. There's an exception in the legislation that allows them to share it with authorities, even absent a search warrant. And so there have been disclosures of information or information sharing that has been happening without people realizing or knowing, having any knowledge of it. And so voluntary transparency reporting is really, I think, a measure adopted by some of these companies to maybe to be more transparent with their customers, to begin to try and take some responsibility with respect to the volume of information they're sharing, maybe also to push back against public authorities because they also disclose how much information is released under warrant. I mean, go online and have a look at Rogers, Bell, TELUS's voluntary transparency reports from 2015, for example, and see how many times the police ask, with or without warrants, for information on subscribers. It's really quite significant. So it's not directly in response to your question, but I think it's an example of where you start to see some kind of response coming, in this case from the private sector, to the burden they're being asked to bear in terms of sharing all of this information with law enforcement.
Yeah, I was just going to add to that, just really briefly, that we've also seen companies getting those requests increasingly willing to push back a little bit when they get ones that look off. But I think more training in ethics, ethical type training, early would have helped that happen at an earlier stage in the development of the internet. It's starting to come out now, and we saw Rogers and TELUS, for example, fought off a request that they felt was excessively broad. I would imagine if they had gotten requests specifically targeting reporters, that might be a thing that at least should set off a red flag, and maybe there's training around that type of training that could be done with telecommunications and other internet companies, so that they know to look out for that kind of thing. So I mean, to that extent, I think there would be a benefit to having ethical training.
Fortunately, if you're searching for Bell's transparency report, you're gonna
This-
have a pretty good.
Very transparent.
Bell's to release transparency.
Yeah, they're the holdout.
No, they won't. Yeah.
I think this is a question for Professor Skaza, that by all means. I'm interested in the fact that it's a JP that the police are going to, as opposed to a judge. Can you speak to that a little bit?
That's simply the way it's structured in the criminal code. I think it's an expediency issue, just in terms of workload and timing, time constraints. So the ability to have somebody who's essentially available at all times. I don't know.
Yeah, I mean, and it's also part of this metadata content discussion. So if you're getting a wiretap for content, you do actually need to go to Superior Court judge. But because it's a combination of a lot of the metadata powers were introduced later, where they've kind of were able to just give them less than they could historically. but also because of this concept that it's less sensitive, they didn't require the full regime that you have for a wiretap for content of a phone call, which does go to Superior Court judge. So.
Is there a movement at all, or to kind of raise the bar or threshold, whatever you want to call it?
I mean, there was a lot of pushback against C31, and there still is, right? There are people who are very upset and concerned, and who have been pushing back. But it's unfortunate once those things become law. Then I think it makes it a lot more difficult, because then you're fighting against what's become the status quo, and I think it's much harder to make the argument than if you're right at the outset saying no, this before we give this power, we have to really put all of these constraints and protections on. Once you've already given the power, then the police will say, here are all these investigations that we're doing and that we've carried out and we've been successful with, and what you're saying is you're going to take this away from us, and that's not in the public interest, and the public is going to be upset about that. So I think it's harder after the horse has escaped to make any difference with the barn door. Whatever.
Good part,
The Canadian Journalists for Free Expression came out today with this morning on a call on government asking to require any warrant for surveillance of journalists to be requested by prosecutors as opposed to police, and approved by judges as opposed to justices of peace. Do you have anything to say about that?
Yeah, I mean, I guess I would say that I think that just looking kind of in terms of as you were saying from a threshold, and you guys were mentioning from a threshold perspective, I think that you can definitely make a strong argument that might ensure maybe more scrutiny, or more perhaps cautious approach to it, as opposed to simply using a JP. Obviously, anything that speaks to perhaps a stricter or a more cautious approach to actually surveilling journalists, I would be inclined to say is a very, very good thing. But again, my colleagues with more experience in the law aspect of it can probably speak more to the legal angle there.
The one thing I would add to that is, and we probably, both Teresa and I work very closely with CJFE, who are on their digital issues committee, so I may raise it soon and encourage Teresa to back me up. The one thing I would add to that is maybe adding a call also to encourage judges to realize that when journalists in particular are involved, they should get a third party, like an amicus, involved, just to have the other side, because it really, I mean, it doesn't come from a bad place. It's not a bad faith kind of thing. It's just your law enforcement, the Crown. We all operate in an adversarial environment. It's very difficult to present the other side when you're applying on your own. So we saw this with CSIS with their metadata program. They just got criticized by the federal court for not providing the full candor that they need to do. I actually don't. I'm sad that they didn't provide the full candor, but at the same time, I understand it's a very difficult exercise to do when you're trying to convince a judge to grant something, at the same time to push yourself to go the extra mile and provide the fullest context possible. So I would encourage. I think that additional safeguard is a useful one to have, appointing an amicus where there's that type of.
I mean, would that part explain the sort of anger in the Noel decision? That it's not just flouting of the law or sort of manipulating the court, that it's our journalistic freedoms and our solicitor-client privilege and our parliamentary privilege and all of those things that CSIS is kind of trampling all over? Samir?
I mean, I'm not saying that, I'm not excusing the lack of candor, which, very righteously has now annoyed 2 federal court judges in as many years, where CSIS has been found to have not provided the full candor that they're supposed to on an ex parte, like when they're presenting the case on their own and no one's presenting the other side. So I'm just saying it may be an unreasonable expectation to expect that standard to be carried out. So and we've seen it now twice fail here, many times fail in the U.S. where they have a similar system with the NSA. So and they also present their issues to a secret court there without any opposition. So I mean, I guess I'm saying on the one hand, I feel the anger is righteous from the court, but it may be an unreasonable expectation. So we need to supplement it maybe with some other safeguards.
Patrick Lagacé, you mentioned that the Lagacé case might represent an example where a journalist is just really asking questions about an exercise of power. To what extent would that kind of surveillance or the chilling effect affect the freedom of expression of citizen journalists or amateur journalists who use platforms like the Huffington Post blog to kind of get their ideas out?
Well, I think if I understand your question correctly, I mean, I think there's always been an issue about both the potential and the reality of abuse of power, abuse of authority. I mean, if you go all the way back to the Roncarelli and Duplessis case, I don't know if they still teach that in constitutional law, but it's a good case, yeah. And it's an important case, right? And it's a case about someone with a lot of power using it to achieve their own ends, essentially, to achieve their own, to cover up, and not necessarily in the case it was of Roncarelli, to achieve particular ends, to cover up bad behavior, to do all these types of things. I mean, I think there's always the risk, although we would like to believe that our public institutions are fair and transparent and accountable, sometimes they're not, and sometimes you get bad actors, and sometimes there are risks that go along with that. And so I think that it's important not only to be vigilant about it, but also to be genuinely concerned about if you have people who are aware of that and either leaking information as confidential sources or trying to dig up information as reporters. I mean, I think in many ways those kinds of questions are some of the most fundamentally important ones in terms of how power is being exercised. So I'm not sure if that responds to your question, but whether it's a citizen journalist or an actual journalist, I mean, if it's an issue of abuse of power, or abuse of authority, then that creates very particular vulnerabilities and a real need to ensure that there's protection.
So a little bit of a comment and then a question for anyone on the panel. So there's a bit of a friction between where privacy and data protection should come from. So some say it should come from government policy, other people say that it's technology will be our savior. For example, Snowden recently said that if you want to build a better future, you're going to have to do it yourself. Politics will only take us so far, and that law is simply letters on a page. But we know that technology can only take us so far as well. So my question is there a place for technology? What are your thoughts on whether it should come from tech, law, or social norms? And of course, being me and my interest in bots and AI, is there a place for maybe like an encrypted chat bot that sources can go to instead of going to a human journalist, and either the bot does the research on their own or with a human, and it's all done through technology without a human, so there's no one really to go after. Just your thoughts?
I guess I can start out with me, go down the line here. I think that it kind of that touches on the kind of interplay between that touches on how complex this is because of the interplay between so many different factors here and so many different interests. particularly when it comes to government versus technology and industry and things like that, I think it's worth noting, when you look at the CSIS case in terms of the recent one of them retaining information or metadata that they had collected via search warrants, they had heard from Department of Justice lawyers that what they were doing was okay, that their interpretation of the law was perfectly fine. There wasn't a problem with that until the court came back and said otherwise. Those were federal government lawyers saying that. And so, again, the law said one thing, it could be interpreted one way. But when CERC looked at it, when the federal court looked at it, and when the public heard about it, of course, they had completely different reactions to what the government and what federal lawmakers in that regard had actually said was going to be okay. And I think that, again, it touches on the fact that we often come at this from two or more different perspectives, really, in terms of our kind of core interest in seeing information protected and seeing information get out. Again, some, I think, branches are more inclined to want to see, to err more on the side of caution. Others are maybe more inclined to err more on the side of ensuring that the public is able to learn what they need to know. But it's a difficult balance. I think you can make the case that again, what society expects and what society deems to be okay is going to be a major factor in shaping how new laws are formed and how the old laws are being interpreted as well. And so, again, if people are informed and they know what they want, and they are able to look at these cases and say, that's not okay. It's not okay that CSIS is keeping information that they may have gotten legally, but there should be more restrictions there, for example. I think that having, again, public a voice is going to play a really key role in that, both for technology companies who are in that role and also for government.
I think there's a big role for both. And it's hard to actually segregate the two because the laws are responsive to technological changes, technology is responsive to legal changes. So you do get into the. I've been really encouraged, again, in the last couple of years, journalists have become a lot more technically savvy in their own practices, which on the one hand makes our job easier when we talk to them because we don't need to explain how to do that. We get it. Well, you're an exception. Many of them were already important, but broader range of journalists, as well as you see reporting entities setting up secure job sites and secure communication options, which I think is great. At the same time, you also see the government saying, maybe we should just ban, regulate encryption or mandate data retention, which would apply to your AI bot as well. So it would have to keep all its interactions.
The journal bot.
Whatever. Sorry, did you have a name for it? So that would apply to the whatever bot as well. It would have to keep track of all the interactions, and that would be available to law enforcement. So, I think the answer is always going to be both. But I think that on the, there's some encouraging things, particularly on the technological side. Tools are being utilized that are out there better. And then other people in the technology sector are recognizing the importance of having these tools, so they're developing new ones. And then on the legal side, though, I think that part needs to come as well, because you can't have, you need both to really have a good ecosystem.
Thanks. I see we're pretty much out of time. I do want to just pick up on something, on Tamir's reference to the prospect of new rules around encryption. Just to make sure that everyone here is aware that this is not just sort of an interesting academic debate. If you're following the media this week in a joint Toronto Star CBC series on privacy and surveillance and the like, it's fairly clear that there's a very strong effort from within law enforcement to not just put this on the agenda, but to try to make the case for backdoors on encryption, which is an issue that I think many people thought had been addressed and wouldn't come up again all the way back into the 1990s. It's back on the agenda, and indeed, in a consultation that is still ongoing, it's still open if you want to find some time to respond to the government's national security consultation. It puts back on the table any number of issues that I think many had thought were closed. Lawful access, for example. Issues around whether or not there ought to be warrantless access to subscriber information. Whether or not telecommunications companies and the like ought to be required to put into place certain interception capabilities within their network. And when you talk about once something's in place, the challenge of going back on it, once you build those interception capabilities within the network, we aren't going to unbuild them. And yet that's been put back on the table. The data retention that we just heard about, and the prospect of backdoors on encryption. So we have really interesting cases to talk about, but we also have right now a very strong effort from within the law enforcement community, an effort to persuade a new government that there is a need for legal change. And so for those that are interested and concerned with these issues, and obviously if you're here, you undoubtedly are, the time is now to ensure that your voice is heard, because that consultation is still open for a couple more weeks. So with that, we're right on 12:50, so I hope you'll join me in thanking all the panelists